privacy comes on the heels of libel, and in some ways it's similar to libel, but in some ways it's also much different. Libel, as we know, involves publishing false things, and one of the key things to winning a libel suit, as we know, is proving that what was said about you is false. Privacy, on the other hand, involves things that are in most cases true. However, they might be things that you don't want people to necessarily know. So, for example, you don't necessarily want people looking at your medical records. You don't want people, looking at the naked pictures that you send to your significant other. Those sorts of things. And so this is one of the things that privacy involves. Privacy also involves when you are a celebrity or something and your image means something, you don't want people to be able to use your image to make money off of you without your permission. And so all of these things are wrapped up in different types of privacy. Privacy law is generally state law, and it does vary from state to state. So what we're going to be mostly talking about in this section is things that tend to be similar in most states. So we're kind of doing an overview of privacy. So to begin with, there are four main types of privacy, and we're going to talk about each of these in more detail, but for now, just to introduce them. First of all is intrusion. An intrusion is basically intruding upon somebody's privacy, intruding upon them physically in their solitude. So again, we'll talk in more detail about what that means. Publication of private facts is the second kind of privacy, and this essentially involves somebody taking information that you believe should remain private and publishing it. Third kind of privacy is false light, and false light is actually pretty similar to libel. It's the part of privacy that's most similar to libel, and it involves not necessarily saying something false about somebody, but giving a false impression. And then finally, appropriation, and appropriation is using a person's name or their picture or their likeness for commercial purposes without their permission. So these are the four main kinds of privacy, and a couple of things. First of all, privacy applies to people only, so corporations don't have a right to privacy. So even though we know, for example, that corporations can sue for libel, they cannot sue for invasion of privacy. Also, and this is perhaps one of the biggest things about privacy is, this class is journalism, law, and ethics, and we talk mostly about the law, but we also talk about ethics. And in most cases, we've seen that laws are based on ethics, and law and ethics both lead you in the same direction. However, what we're going to see about privacy is, in a nutshell, legally, it's okay to do a whole lot of things. However, ethically, most journalistic organizations don't do them just because they don't think it's right. And again, when we get to some examples of this, you'll see more what I'm talking about. But generally speaking, privacy law allows the media to do a lot more things than they actually do. So let's talk about, first of all, intrusion. And intrusion basically says that it's illegal to intrude physically or otherwise on the seclusion or solitude of an individual. So this essentially means, somebody intruding upon you in your privacy. So one of the interesting things about intrusion compared to other types of privacy is intrusion only requires the act itself. So in other words, like once somebody intrudes upon you, they don't actually necessarily need to publish anything. The intrusion is actually where the law has been broken. And you can almost think of intrusion, even though it's not exactly the same, but intrusion is sort of similar to trespassing. Again, it's not exactly the same, but it's sort of that same idea. So the idea of intrusion, though, kind of depends on what your expectation of privacy is. And so this comes down to whether you are in a public place or a private place. So first of all, talking about a public place, generally speaking, you don't have any expectation of privacy when you're in public. So essentially the media can record and, basically do anything they want, pictures of you, whatever, when you're in a public place. That didn't sound good. Hold on a second, kids. Something fell. Okay, I'm not sure what happened there. Something fell in the other room, but I went over there and I couldn't see anything. So anyway, we're talking about public places, and as I was saying, when you are in a public place, you really have no expectation of privacy. So that means if I am on public property and I have a video camera or a still camera or an audio recorder, I can basically record anything I want, and you cannot sue for intrusion. So I show this picture, and you might not know who this is. I'll tell you who this is. This is Jackie Kennedy Onassis. She was married to JFK, and she sort of became the first sort of mega celebrity, sort of like Princess Diana in a sense. So she was just somebody who, the public was just fascinated with everything about her. And there was this photographer named Ron Galella who more or less made his living just shooting pictures of Jackie Onassis. And as I said, she was so popular and people wanted to know so much about her that there were constantly magazines that were willing to buy pictures of her, just walking around. And she eventually sued him for intrusion because essentially what was happening was, she couldn't even leave her house. Like she would walk out the door of her apartment. I think she lived in New York City, or at least had one house in New York City. She would sort of walk out of her apartment and he'd be right there snapping pictures. She'd try to walk across the street and, she'd be tripping over him. And essentially what happened is she was able to get a restraining order that basically said that he had to remain 25 feet away from her. So the reason I bring that up is just to illustrate this idea that yes, you can shoot whatever you want from a public place. However, if you get to the point where you're kind of harassing somebody, or if you are, impeding with their ability to move around, well then that brings up another issue. And so if that sort of thing is happening, you can go to a judge and, get an injunction or a restraining order that basically would say, hey, this, you have to, remain so far away from this person and you can't be, continually harassing them. But bottom line, if you're in a public place, you have very little expectation of privacy. Now, if you're in a private place, things are a little bit different. And first of all, there is this idea of consent. And consent essentially means you've been given permission to be in this private place. And it can be either explicit, meaning that somebody says, yeah, come on in, or it can be implied, where essentially they allow you in. And so one of the cases here is this Dietman versus Time case, which involved a quack doctor who was working out of his house, and a couple of reporters from Time magazine posed as potential patients. They had a recording device. They went into this guy's house, which was his office, under the guise of being a potential patient, and he let them in. They recorded all of this, and the guy whose name was Dietman eventually sued, and the court ruled against the journalists. The courts essentially said that the First Amendment doesn't provide you a license to trespass or to intrude into somebody's home. And this is a case that makes it seem like, well, you can never take a hidden camera or a hidden recorder anywhere. But it really isn't, because what was special about Dietman versus Time is that his office was actually his home. And so it is, generally speaking, okay within limits for a media organization to have hidden cameras or hidden recording equipment in a place like a store or an office or something like that. As I said, the Dietman versus Time case, what is unique about it or special about it was the fact that this guy worked out of his house. So if you're actually going into somebody's house, the criteria are different than if you're going into basically somebody's office. And as I said, other cases have offered more protection for journalists who want to do these kind of things. And so, generally speaking, this is what allows media organizations to do stories like where they go in with a hidden camera to like a mechanic, and they will go into like the Midas muffler or whatever, and they'll sort of show a thing of like how a mechanic's doing something shady with a car or something like that. So generally speaking, those kind of things are okay because they're basically at a place of business, which is sort of considered a quasi-public place. All right, and then similar to this, or at least related to this, is the idea of police ride-alongs. And this is the idea where sometimes the police want to get, good publicity about a drug bust or something, and so they will invite journalists to go along with them as they go and, do a search warrant or raid a drug house or something like this. And up until 1999, the understanding was sort of like, well, yeah, of course the media can do this. And the police are freely within their right to, invite the media to come along with them. And what Wilson versus Lane changed, and this was a Supreme Court case, is the Supreme Court basically said that it is a violation of privacy if journalists go with law enforcement organizations into a private home. So, again, what has happened since Wilson versus Lane is police have to be very cautious about providing so-called permission for journalists to ride along with them. Generally speaking, the courts will say, well, the police have the right to come into somebody's home if there's a search warrant, but they can't bring journalists along with them. One more thing to talk about intrusion here is the concept of recording telephone calls. It varies by state as to whether you need permission from the other party. If you are talking to somebody and you want to record. In Ohio, you basically only need one party's consent. In Michigan, however, you actually need both parties' consents. So recording telephone conversations is another sort of issue of privacy. Okay, our next kind of invasion of privacy is private facts. And private facts says that it's illegal to publicize private information about a person if the matter that is publicized, A, would be highly offensive to a reasonable person, and B, is not of legitimate public concern or interest. Now, it is generally pretty hard to win a private fact suit against the media for the following reason. That reason is that if the media can show B, it overrides A. In other words, if the media can basically demonstrate that what they're talking about is of legitimate public concern or interest, it overrides the offensiveness or the privacy aspect. So in other words, what the media can do is essentially say that, hey, this is newsworthy, this is something that's of public interest, and so therefore we can do this. And this is probably like the main area where I think the public and the law are kind of out of step. A lot of people already think that the media goes way too far in intruding upon people. But generally speaking, as far as the law goes, if the media can show that there's public interest in something, it's okay for them to print it. One example of this involved a guy at a Pittsburgh Steelers game during the 70s. He was all dressed up in some sort of, Steelers garb, and he asked a photographer from Sports Illustrated to take his picture. The photographer took his picture, and the picture ended up being printed in Sports Illustrated. However, when the picture was printed, the guy noticed that his zipper was down, and so he sued for invasion of privacy. However, the court said, nope, you can't do that. A, you were in basically a public place. B, you asked the photographer to take your picture, and so, you're out of luck on that one. Another case, though, Cape versus Bridges, is more of a sort of newsworthy type story. And this involved a woman who was being held hostage by her husband in a hotel room in Florida. I don't know all the background of this, but essentially what happened was she was being held hostage. She was naked. Her husband had a gun. The police were notified, and so for a while the police were basically outside this hotel room, sort of trying to talk the guy out, waiting for something to happen. In the meantime, journalists also came to the scene, and eventually what happened was the guy shot himself. When that happened, the woman ran out of the hotel room. She just basically had a towel over her, and you can see the picture here. And the local newspaper took this picture and printed it. She sued for invasion of privacy. Originally, the jury at the trial court awarded her $10,000, but later an appellate court overruled and essentially said that the newspaper had the right to publish that picture because it was a newsworthy event. And so, even though, as you can see here, this is like the worst moment of this woman's life, and she obviously would rather not have her picture taken because she became involved in this issue of public importance. It was okay for the media to print this. And this is kind of an important concept. I mean, you can sometimes get involved in something that is of public interest through no fault of your own. If you have a spouse who goes crazy and holds you hostage, I mean, that's going to become a newsworthy event. If you get run over by a drunk driver as you're, just walking on the sidewalk, that can become a newsworthy event. So the idea here is, and I have it there at the bottom of the slide, where public interest essentially trumps everything. So if the media can show that something is of public interest, it's okay for them to print it. Okay, so then we talk about this concept of naming rape victims. There is debate about whether media organizations should reveal the names of rape victims. The media used to do this routinely. However, most media today don't publish the names of rape victims. The idea behind not doing that is that women are further victimized by the publicity, that society can sort of judge a woman as being somehow guilty, the sort of stigmatization idea, where people say, oh, she must have been asking for it, she had those high-heeled shoes on. That sort of thing. And finally, just this fear that women won't report rapes if they're worried about the publicity behind it. So there have been states that have tried to enact laws that prohibit the publication of rape victims. And one of the states was Georgia, which brought up the Cox versus Cone case. And Cox versus Cone involved the murder and rape of a 17-year-old girl. 6 youths were charged in this crime, and it was like a pretty big deal in Atlanta. However, the victim's name was never revealed. Even though it was part of the public record, the name of the victim was never revealed by the media. However, at one point, a reporter did reveal the name, which, as I said, was contained on the court record. The victim's father sued, claiming his privacy had been invaded. This case eventually reached the Supreme Court, and the Supreme Court said, basically, no, you can't sue for invasion of privacy because you can't publish the media for, you can't punish the media for publishing something that's part of the public record. Similarly, in the Florida Star versus BJF case, And once again, we see initials BJF. That tells us that this is a minor, a person under 18. Florida had a law that prohibited naming rape victims. A reporter got the name of a rape victim from the police record and printed it. It eventually reached the Supreme Court, and once again the Supreme Court said you cannot punish the media for publishing something that's part of the public record. So they said if you don't want the media to publish the names of rape victims, make sure it doesn't appear in the public record. Because the court said if we start prosecuting the media for printing or revealing things that are part of a public record in a legal proceeding, will really have a chilling effect on the media, and they really essentially won't know what they're able to print. And so, generally speaking, as I said, if it's part of the public record, the media can print it. Okay, I want to talk a little bit about social media and online sites, because I think this is a thing that I think people are getting a little bit more savvy about this now, but some people still have a pretty naive sense of what's going on when you put something like on a site like Facebook. Essentially, like when you post something on Facebook, you have essentially lost control of it. So even if you just post it and share it with one person, it's basically out there. And it's on Facebook servers. That person might share it with somebody else. Somebody else might share it with somebody else, and you might delete it, but somebody has already kept a copy of it. And so bottom line is you need to be real careful about posting something on social media sites. And even though there hasn't been a legal case that I know of that has happened about this yet, I think at some point what's going to happen is somebody's going to post something that they're just going to share with a couple of their friends. Maybe it's a kind of embarrassing picture of themselves. One of the friends is then going to put it out and share it with everybody, and that original person's going to try to sue that second person for distributing it. And I kind of tend to think that a court is going to say, sorry, you put it out there and this person further put it out there. Tough luck. But it will be kind of interesting to see what happens in a case like that comes up. But bottom line on social media is you really need to be careful about what you put out there, because once you put it out there, it's out there. Okay, false light is our third kind of invasion of privacy. And as I said, this is similar to libel. And false light says that you can't publicize material that places an individual in a false light if the false light would be offensive to a reasonable person and the publisher of the material was at fault when the publication was made. All right, this is much more complicated than what it really is. Essentially, false light is just sort of giving a mistaken impression about somebody. So as I said, it's similar to libel, and in a lot of cases it involves things like photo selection. So for example, there was a case where a magazine called Ladies Home Journal, which I'm not even sure if it exists anymore, they were doing a story about love, and they had a photographer who went into Central Park or someplace and basically took a picture of this couple, and it was a guy who had his arm around the woman. It turned out that they were married to each other. They're in a public place, they're in a park. The photographer took this picture. However, when it ended up in Ladies Home Journal, it appeared with a caption underneath that said, "Love at first sight is a bad risk because it's based on 100% sex attraction." So this couple sued because essentially what they're saying is, well, people could see that and people know us, and essentially what you're saying is that our relationship is based on 100% sex attraction, and it's wrong. And the couple sued and won. And so this is a prime example of how, you need to be careful about giving a false impression about somebody. This can also come into play in television when you use file footage. Like a lot of times there will be, a story that comes out that says, I don't know, just coming up with an example off of my head. Like, let's say there's a study that says that 20% of people are HIV positive. So to illustrate that story, a local media organization might just use their footage of like people walking around downtown, so crowds. Because a lot of times TV stations basically just use what we call file tape to illustrate these kind of stories. And what you need to be careful about when you use file tape is make sure that you don't show people's faces. Because if you show somebody's face, essentially at a time when you're saying that 20% of people are HIV positive, you're essentially giving the implication that that person is HIV positive. So again, you just sort of need to be careful about using pictures and using illustrations that actually don't go along with what the story is about. Finally, appropriation. Appropriation is also sometimes called commercialization, and appropriation says it's illegal to appropriate an individual's name or likeness for commercial or trade purposes without their consent. So this essentially means using somebody's name or picture in an advertisement without getting their permission. Now, for most of us, we really don't have to worry about appropriation much because none of us are famous. And, me, for example, like nobody wants to put my name or my face on a pair of tennis shoes or on any kind of athletic equipment or clothing or anything like that. But if I'm, like Shaquille O'Neal or Peyton Manning or Tom Brady or somebody like that, well then, yeah, my name and my likeness is worth something, and I want to be able to control what people can do with that. So appropriation actually recognizes two separate rights. The first of those is a right of privacy. And there's this term shame and humiliation, which basically comes from the idea that if somebody just started putting your name or your picture on a product or on billboards and started using it to sell something, you could be shamed and humiliated. For example, if somebody just took a picture of me and then they start, putting my picture on, Depends, and they basically use my picture, on the box of Depends and on billboards and every place else, like advertising this, obviously that would cause me some shame and humiliation. The second right is the part that famous people come into play. And this is the right of publicity. And right of publicity essentially says, well, you have the right to control your image, your name, and your likeness. So in other words, if you are well known, people know your name, they know your face, they know your likeness. Again, and when we talk about likeness, think of like the Air Jordan logo, which is essentially, him kind of flying through the air with a basketball. That's an example of a likeness. It isn't actually his name. It isn't actually identifiable as Michael Jordan if you didn't know it already, but it's sort of an iconic image, a likeness that is associated with him. And again, right of privacy says you have the right to control the use of your image, name, or likeness. And it even extends to characters you've played. There was a case, if you know the show Cheers, where there was like the mailman and the other guy who were always sitting there at the bar. There was a bar in, I forget where it was, but they basically had these like animatronic robots sitting at a bar of those two guys. And one of them sued and basically said, well, you didn't get our permission to use this, and you're sort of using our name and our likeness without our permission. And the court ruled in their favor. This right of publicity can also be passed on to your heirs after you die. And this has come into play with digital manipulation, where, for example, we've seen like beer ads where John Wayne, who died many years ago, appears in a commercial where what they've done is dubbed in like his, a scene from a movie and show him like drinking a Coors beer or something like that. And so again, the important thing here is that can be passed on to your heirs after you die. And this idea of lookalikes and soundalikes, we really need to be careful about this. For example, this Bette Midler Ford case. Bette Midler is a singer. She had a particular song. What song was it? Let me see here. My notes are out of order. In any event, we don't need to know what the song was, but essentially Ford wanted to use one of Bette Midler's songs in one of its commercials. They asked Bette Midler, and Bette Midler wanted too much money, and so what the advertising agency that was working with Ford did was they just had somebody else who sounded like Bette Midler record the song, and they used it in the commercial. Bette Midler sued, and she won, because essentially what they said there was that all you have done is you've basically kind of weaseled your way around getting, my permission, and you've got somebody that sounds just like me, and, it's clear that they're imitating me, and so that's bad. Now, there are cases where it's clear that, it isn't actually the person. For example, I know there's a Kia dealership here in the area that from time to time will have like a look-alike of President Obama. They used to have President Bush. They've even got a President Clinton. And they'll come on and say, you should buy a Hyundai. I'm George Bush and you should buy a Hyundai. And that's like a case where people essentially know that it really isn't George Bush doing that, and they will put a little thing at the bottom, like a disclaimer that says celebrity look-alike. But, once again, nobody except the stupidest person is going to think that, George Bush is actually doing Kia commercials in Toledo. So if it's clear that you're not really implying that that the look-alike person is that person, then it's okay. Okay, another case here involved Vanna White and Samsung. And Vanna White, I assume is the woman who turns the letters on Wheel of Fortune. She doesn't even actually turn the letters anymore. She just touches them. And Samsung had this ad, which is about one of their VCRs, and it showed a robot basically turning letters with a blonde wig and a dress. Vanna White sued for appropriation and won. And most people think that this is pretty ridiculous that she was able to win this. However, it does stand as a decision that has been made, and so, you sort of need to be cautious about, well, where does this idea of appropriation actually stop? It isn't actually her name. It isn't actually her likeness per se. I mean, it's something like her, I suppose, and certainly most people who would look at that would know what they're trying to convey there. But as I said, a lot of people think that this was really like sort of a bad decision. However, it does stand, and it sort of does illustrate this idea of appropriation. So there are some exceptions. First of all, consent. If somebody gives their permission to use their name or likeness for a commercial or something, you can do that. News is also an exception. So if you're doing a legitimate news report about somebody, you can use their name or likeness. The Booth rule talks about magazines, and for example, like let's say People magazine does a story about Tom Cruise, and they put Tom Cruise on the cover of People magazine. The Booth rule says that People magazine can use that cover to promote its magazine. So in other words, if then People magazine had a TV commercial and they say, you should subscribe to People today because it's got information about all your favorite stars, and they show that cover of Tom Cruise, even though they're sort of using Tom Cruise's name or likeness for commercial purposes, and they haven't actually got his permission to do that, the Booth rule says that because he did give his permission and they did do a story about him that was, a news story or whatever, and it was in the magazine, you can actually use that for promotional purposes. Also, political ads are an exception, so you can use your opponent's name or likeness in a political ad without having to get their permission. And another exception is what we call transformative value. And this is when you've taken something and taken somebody's image, but you've made it into an artistic statement or a parody or something that is transformative. As an example of this, here is a painting that was done by a guy who does like different kinds of golf paintings. And he has an image of Tiger Woods here, and what he has here, and I don't know much about golf, but this is the Masters, and I think it's showing like other people that have won the Masters and showing like Tiger Woods as being the latest person to win the Masters. Tiger Woods initially sued him for doing this, but the court essentially ruled that, well, yes, it is Tiger Woods' likeness. However, this isn't, directly a appropriation, because what this artist has done is sort of taken Tiger Woods' likeness and he's combined it with likenesses of other people and images from the Masters. And you can see like images in the background, that blue part, if you look closely, are various images of the Masters. And so they said that this was transformative value. And they basically said that, yes, even though that is Tiger Woods, this person has essentially taken this and sort of made it into something that is more than just Tiger Woods. And then another exception is if the person is not actually identifiable. Okay, so here's an example of this. This is an iconic image from the Oklahoma City bombing that happened in 1995. This was a firefighter rescuing an infant from the bombing. And this sort of became an iconic image that sort of came to illustrate the whole Oklahoma City bombing. Everybody had seen it. That sort of thing. And a company ended up using this in an advertisement of some sort. I forget what they actually did with it, but the mother of the infant sued, but the court essentially said, well, you can't win a libel suit, or a privacy suit here, because the infant isn't actually identifiable. Yes, you know that it's your son, daughter, but the average person looking at this wouldn't be able to identify the person. So in a case where you're not actually identifiable, you basically can't sue for appropriation. Okay, so there is your overview of privacy.